So, it seemed the police had the key evidence they needed to convict Wendell Baker. But there was a big problem, and it was all about the way detectives had got that first DNA match. And it was serious, could even undermine the whole case against Baker. When Baker was arrested for the burglary in Hackney, the police were allowed to take a saliva sample for DNA testing. The law at the time stated all samples can remain on the database if a defendant is convicted, but crucially must be destroyed if a suspect is acquitted of a crime. Remember, in August 1998, Wendell Baker was tried and found not guilty of the burglary in Hackney.
And as a result of that acquittal, the DNA profile that had been obtained from him should have been destroyed.
But it wasn't. For some reason, Baker's DNA profile was left on the database, and that broke the rules. And that meant the saliva sample and the hair sample taken from Baker were unlawful. It was possible that a judge might decide the DNA evidence was inadmissible at court. Despite concerns over the legal status of the DNA evidence, the Crown Prosecution Service decided to continue with the case against Baker. On the 16th of June 1999, at the Old Bailey, Wendell Wilberforce Baker stood trial, charged with the rape and assault of Hazel Backwell and the burglary of her home.
Clearly it was a very precarious position for the Crown, and our backs were against the wall, and we had to concede that the saliva sample, should have been destroyed.
The prosecution faced a well-prepared defence team who were determined to have the DNA evidence ruled inadmissible.
A substantial amount of time was put into research to try and see if we could give the judge an opportunity to allow us to rely on clearly what was extremely compelling evidence to prove that this defendant was guilty of a really abhorrent attack.
Before a jury was even sworn in, the prosecution and defence made their arguments to the judge.
Your Lordship, the counts on this indictment,
whether the DNA evidence could or should be admitted.
Supported by clear, compelling and incontrovertible DNA evidence which links the defendant to each of these offences.
Despite the irregularities, the prosecution thought the judge would allow it.
I was confident that we would win it because English judges retain a discretion to admit unlawfully obtained evidence. And in this case, the Crown's view was that the judge should exercise his discretion to admit this evidence. It was very powerful evidence, and it was evidence that should have gone before a jury, and for a jury to decide his innocence or guilt.
The Crown argue that your Lordship has a clear and inherent discretion in the circumstances of this case, which properly allow your Lordship to rule this evidence as admissible.
And there was good reason to believe the judge would put the evidence before a jury.
I was aware that there was at least one other case where DNA profiling, which the defence had said had been unlawfully obtained, was permitted to go before the jury.
This whole problem of whether or not the DNA evidence was legal could have been avoided had it not been for one simple failure in the original police investigation. Police are allowed to keep DNA profiles of everyone who has committed a recordable offence. Remember though, when Baker was arrested for burglary in Hackney, he gave a false name, Orton Brown, who had no previous convictions. The police didn't check the name he gave at the time. They didn't spot the lie. That simple mistake was preventing the prosecution from using Baker's DNA sample as evidence.
If the officers in the case had have been aware that he also went by the name of Wendell Baker, they would have seen that he had what was deemed a recordable offence for a fray. And they could have taken the saliva sample in relation to that, and the sample could have been held on the Police National Database so that the Crown could have proceeded against him without any of these technical difficulties arising.
We wanted the police to take part in this film. We wanted to know why they so readily accepted Wendell Baker's lie when he gave a false name. And we wanted to ask them about the missed opportunity to hold on to Baker's DNA profile. The police said that they couldn't comment on or get involved in this case. But I understand from officers that they believe they made no mistakes, that Baker's false name was spotted within a few days, and that back in 1998 it wasn't the Met's policy to hold on to DNA profiles in this way.
This meant, though, that the police had used the DNA evidence unlawfully, and that was the defence case, that it simply shouldn't be allowed. In the end, it was down to the judge. And if he agreed with the defence, that key piece of evidence would be gone, and the case against Wendell Baker would be gone with it.
We felt that in all the circumstances of the case there was such merit in the argument, and that it couldn't have been in the minds of the legislators to allow somebody to walk free without punishment, where clearly there was such strong and conclusive evidence against the defendant.
The judge had listened to 2 days of argument before coming back with his decision.
The consequences of these rulings of mine is that whether it is on the basis of principle or the basis of practice, the matter cannot go forward.
Extreme disappointment. I think one's always disappointed when one loses a legal argument which one thinks is correct and has merit.
In those circumstances, I would invite the jury to return not guilty verdicts, and the defendant is to be released.
Hazel Backwell never went back to the house where she was attacked. She gave up her home of 30 years and moved to a warden-assisted flat with better security. She gave up her friends, her beloved cat, and she moved away. Hazel died 5 years later.
She lost her sense of well-being, she lost her ability to go out and just enjoy life and wander around, and go on public transport, and meet people for the first time. All of that was taken away from her, and she was towards the end of her life. And the end of her life was ruined. An individual's life was ruined by this offence.
Wendell Baker is now in his early 50s, but his criminal record has continued to grow since his acquittal for rape. A drug user with a history of violence, he now has convictions for knife carrying and theft. His release back onto the streets in 1999 not only ruined Hazel's last years, living in fear of his return, it has put the public at risk of his violent nature.
This is a case that raises enormous questions. Not least, how could it happen? How could evidence that proves the guilt of a defendant not be shown to a jury? And how could a violent rapist be put back on the streets as a free man?
Baker's trial did do one thing. It caused an argument that split the legal world on whether the DNA evidence should have been admitted. We asked one of Britain's leading experts on what can and can't be put before a court, what he thinks of the judge's decision in the Baker case.
It seems to me, reading the legislation, that it would have been admissible. If I had been the judge, I would have said that the evidence was good quality and that there was nothing unfair to the defendant in admitting it.